Up and live?
Yes, Mr. Chairman, I'm going live right now. I'll let you know. We are live, Mr. Chairman.
Thank you.
You're welcome.
So, ladies and gentlemen and committee, this is the Ag Committee. We are here to discuss Senate File 25, animal impoundment. And we will call roll.
Representative Blackburn.
Here.
Representative, Vice Chair Clausen.
Here.
Representative Fortner.
Excused.
Representative Heiner.
Here.
Representative Larson.
Here.
Representative Western.
It'll be a little late, excused.
Okay. Representative Worf.
Here.
Representative Winter.
Here.
Chairman Eklund.
Here.
7 are present, 2 excused.
Okay, thank you. So our first bill for consideration is Senate File 25. And I believe we've had 3 members of the committee that were here during the interim. It has changed a little bit on the Senate side, and I would like for Representative Clausen to present the bill. So if you'd like, or you can do it from your desk. Why don't you just do it here?
Thank you, Mr. Chairman. So I guess the first thing I'll do is kind of give a little bit of an explanation of the overriding issue so everybody kind of knows where we're at, because it's a little bit complex. But the overriding issue that we were trying to deal with was on the impoundment of dogs and cats. Well, not just dogs and cats, but pets in general in like humane societies or animal shelters, specifically the one in this city, but animal shelters around the state. A lot of times in abuse cases, they end up with the animal, and the way the statutes currently are, the owner of the animal can't make a decision or chooses not to make a decision as to whether they take the animal back or make the decision to forfeit the animal. So usually almost always it's in abuse cases. So they can't make the decision to forfeit the animal. And so the care of the animal is, the cost of care is basically allocated to the animal shelter, which is basically the county or the city. So somebody else is caring for it. In some of these cases, it's gone on for months and months and years. And by the time the animal everything's through the process, the animal's been in the kennel so long that they call them kennel crazy, to where they're no longer any good, or their minds are, you can just imagine it's not good for the animal. So what this bill does is set up a structure. So the owner of the animal in these animal abuse cases puts up a bond. They have 10 days to decide whether they're going to forfeit, and then the animal shelter can adopt the animal, or if they're in really, really bad shape, they can go down some other path. But if they decide that they want to keep the animal, they put up a bond of care for up to 90 days. So they have to pay for their care for up to 90 days. And this goes before a judge, and the judge just kind of decides what it's going to be. So there's not exorbitant costs or something like that. It's just more along the lines of normal care. I think it's in the bill. It's feed, reasonable cost of impoundment, which would be the amount the circuit court does or decides, which is page 2, lines 7 through 14. It's limited to a reasonable cost for impoundment shall include, but are not limited to, costs for the transportation board, nutritional care, vet care, and diagnostic testing. So basically the normal care that the animal would have to have if it were in the care of the animal, nothing exorbitant, but the judge sets that's kind of the fail safe. Uh, That's the general overriding issue. Then, Mr. Chairman, I think I'll just kind of go through the bill and explain what it does. Is everybody clear on the overriding issue, or do we have any questions there? Okay. I don't think your mic's on.
Go ahead, Representative Clausen, walk us through the bill.
Okay,
please.
so page 2. Any person with the authority to enforce this article, which that's the sheriff, the dog catcher, people with the authority, who had probable cause to believe there's violation, so they can't just go out and do it. And usually in these cases, the things are real bad before anybody, they're not randomly taking action. It's not something they're seeking out. Usually in these cases, through the testimony in the summer, things are pretty out of line before these actions are taken. But so anyone who has probable cause to believe there's a violation of this article may impound an animal, and any animal treated cruelly. So they have to have probable cause. The following action shall apply. So if the animal is impounded, the animal or the owner shall be liable for all reasonable costs of impoundment, and shall be required to post a bond with the circuit court in the county where the animal was impounded. Reasonable costs of impoundment shall include but are not limited to costs for the transportation board, nutritional care, veterinary care, diagnosis tests. And the thought behind this section was these would be normal costs that the owner would incur whether the animal was at the shelter or not. So they would have to feed it. If it was at home, they would have to take care of their veterinary and so on and so forth. Then on the bottom of page 2, line 16, and the amount the circuit court is sufficient to provide all reasonable costs of the animal impoundment for at least 90 days. So it's 90 days worth of care. Up to 90 days worth of care is what they can put on this bond. And if things are real bad, they can determine the sufficient to provide for the final disposition of the animal. This whole thing has to be filed with the court within 10 days. So the owner actually has 10 days to decide, okay, do I want to post this bond or do I want to give up the animal? And that's sort of the portion of this bill that takes care of the overriding issue. So it forces a decision within 10 days. So these pets aren't sitting in the animal shelter for months on end, basically going insane. So that's kind of the meat of the thing right there. Moving on to line 4. Let's see. So if it goes on past the 90 days, the owner shall post a new bond with the court. Just kind of goes into there. As used in this section, so dispose means a place for adoption, to sell or destroy. So in cases, I mean, the ideal situation was if they're in these shelters, they'd be adopted. If for some reason the situation's pretty bad, it has another means. If it's livestock or something of value, they have to sell, or they can sell the animal if they don't put up a bond. Moving on. Okay, on page 4, if the court orders the forfeiture of the animal, which these are in animal abuse cases, or the owner voluntarily forfeits the animal, no animal should be forfeited through this section, regardless of whether the bond is posted, if the animal is connected to the livelihood or ability of the living owner. So this is sort of a protection for people. So it's not sort of a protection, it's protection for livestock people. And it would be a protection, let's say if any of these animals were to do with the livelihood of the owner, if this is how they make their living, whether they put a bond up or not, it can't be forfeited. A protection in the law. Let's see. Moving on. Line 10, if the bond has been posted in court in accordance with. Oh, it shows how the animal shelter, so line 10 through 16 tells how the animal shelter can draw on the bond for care of the animal. So they don't automatically get the funds. They can draw on the bond, and it tells how they bill the bill for the care. So it's not a just here's a blank check. Lines 18 through 22, upon final disposition of the animal, and remember, disposition means either adoption or some other means if they had to be destroyed. If there's any bond amount left, it shall be given back to the owner. So that's lines 18 through 22. So if there's any bond amount left, when the case is decided, either they're found innocent and they get the animal back, any bond amount left goes back to the owner. Or in the case where it's adopted, they decide to give something else happens. If there's anything left at the end, it goes back to the person that put up the bond. Let's see. Next page. Okay, page 5 deals with more of the court process side of this. Person with the authority to enforce this article or other participants in criminal action may file a petition in the criminal action requesting court issue an order forfeiting the animal to the person with authority to enforce this animal. So if the animal abuse case turns out bad and the court decides that they shouldn't get the animal back, this section says that they can force the person to forfeit the animal, and that they don't sit in the animal shelter for months and months and months. They can adopt it or do something with it. Let's see. Moving on, line 13, if the case charging of this violation is pending, and they haven't decided the case, line 16 through 17, upon receiving the petition, then they get a hearing. So if it hasn't been decided, the person gets a hearing within 7 days after the filing for a petition. And the hearing shall be listed just for the forfeiture of the animal. Lines 4 through 20 talk about the hearing. So it's lines 4 through, I'll just read through this. It makes more sense. At the hearing conducted pursuant to paragraph 5, but subject to the prosecutor has the burden to establish probable cause to believe that the animal was subject to a violation. So they have to have probable cause before they can use any of this law. The finding of probable cause to proceed on the criminal case will create a rebuttable presumption that probability exists for forfeiture proceedings. That means that the judge has to decide, yes, they did something that the animal needs to be forfeited. After the hearing, if the court finds probable cause exists, the court may order immediately forfeiture of the animal, which this goes back to if there was serious abuse charges, the court can automatically say, no, you're not getting this animal back. We're automatically forfeiting it and we're going to adopt it out. If they find no probable cause exists, the animal shall be returned to the owner of the animal, and the owner shall not be responsible for any costs. This means if this is a fail safe. So if somebody comes in and says there's a problem, they go to court, everybody realizes there's not a problem and the judge says it's fine. The owner is not responsible for any of the costs of impoundment. And they get their animal back. So that's sort of a fail safe, lines 15 through 20 on page 6. All right, page 7. So we change, I believe these are set changes. Page 7, line 9. Any piece.
Hang on a second, Representative. So that was a created statute concerning more of the pet industry. and abuse there. And now we start into animal impoundment of animal
Yeah,
livestock existing.
sorry, Mr. Chairman, the stuff gets a little complex.
Yep.
And it's been a while since we worked on it. So page 7 goes into the livestock portion, and most of this structure was already in there for livestock. And we just cleaned it up. When you look at the earlier statutes, we did clean up on this. This was a cleanup. So we went from any person with or any peace officer, agent, or officer to any person with authority who has probable cause to believe there's been a violation of this chapter may impound any livestock animal treated cruelly. And that's just cleaning up the language. This is old statute, but so the livestock statutes had they had a means before to impound the animal and get it back. Let's see, any livestock animal is impounded under this subsection. The owner of the livestock shall be liable for reasonable costs of impoundment. This basically the same thing as the dog or pets, household animals, but as dealing with livestock. Impoundment shall include, but not limited to, costs for transportation, board, nutrition care, veterinary care, same thing. Normal care you would have to have if you had the livestock at your place, but since it's somewhere else. The language most of this language is already here, kind of a cleanup. All reasonable costs of the livestock's animals impoundment for 90 days. The bond may also include the amount of circuit court that determines is sufficient to provide for final disposition of the animal. So same kind of process, and this process was already in place for livestock. We just cleaned it up. Let's see. Bottom of page 8, line 19, the court may correct, alter, otherwise adjust the new bond upon a motion made for expiration date of the previous bond. That means they can extend the bond if the thing's not taken care of in 90 days. There's other kind of costs. Let's see, page 9, line 5 goes back into what dispose means. It shall be also mean to place of adoption. Let's see. Line 9, posting of a bond shall not prevent the person with authority to enforce this chapter from disposing of the impound livestock before the expiration of the period covered by the bond if the court orders the forfeiture of the animal. That means if there's something's real bad, the court can order them to sell or adopt the animal. Section. Or if the owner voluntarily forfeits the livestock animal, no animal shall be forfeited without having a hearing. So you have your day in court before anything's forfeited. Regardless whether a bond is posted, if the animal is connected to the livelihood or ability of making the livelihood of the owner. That means if it's something connected to your livelihood, it can't be forfeited without a hearing. You get to go through a hearing and say, this is what, why, where. Same clause we put into the pets statute, and those were Senate amendments. Let's see. Page 10. Some cleanup language at the top, line 1. Let's see, line 7, final disposition of the livestock animal, any bond amount remaining that shall not be expended in the impoundment of the livestock animal shall be remitted to the owner or keeper of the livestock. That means if there's anything left on your bond after this date or after the hearing's over, it goes back to the person that placed the bond. Lines 12 through 17, a person with authority. A person with authority to enforce this chapter or other participant in the criminal action may file a petition in the criminal action requesting that the court issue an order forfeiting the livestock animal to the person with authority. That means if it's real bad, the court can order the forfeiture of the livestock animal to someone who can care, which is just livestock board usually. Let's see. Bottom of the page, livestock animal is in the possession and being held of a person with authority to enforce this chapter. And the outcome of the criminal charges are pending. The final disposition of the livestock has not occurred. Upon receipt of petition pursuant to this subsection, the court shall set a hearing on the petition for forfeiture of the livestock animal, and the hearing shall be conducted within 7 days after the filing of the petition, or as soon as practical thereafter. The hearing shall be limited to the question of forfeiture of the animal. That means you have 7 days, or they have 7 days to say, yes, we are going to do a criminal action, or no, we're not. Let's see. Bottom of page 11, it establishes that they have to have probable cause to believe that the livestock animal was subject to a violation. And did she get a hearing? And the same language we had in the pet statutes. And let's see, page 12. So it goes back to, it's a similar language. If the person with authority to enforce this, after the hearing, the court finds it has no probable cause, the animal will be returned to the owner or keeper of the livestock, and the owner shall not be responsible for any reasonable costs. That's fail safe. If somebody has a false accusation and the judge says, nope, everything's fine, they get the animal back, and it may have a slight amendment in this section, but Mr. Chairman, clear as mud on, and I'll make a stab at answering any questions, and I may have to call on one of our good colleagues that deals in this sort of stuff.
Okay, questions, committee? Yeah, Representative Winter.
Yes, thank you, Mr. Chairman. I really have a problem with a good part of this bill. The first part dealing with dogs and cats and so forth, I can kind of understand some of that, but when it comes to the livestock portion of this bill, it talks about those people, a person who has the authority to enforce. And evidently, he's the one that makes the decision if an animal is poorly treated. Now, we all know that the livestock board has provided, or the legislature has provided the livestock board with money to train some of these police officers and sheriff's officers in these counties to understand livestock a little bit. And that should tell us something, that the people don't understand livestock this day and age. Very, very seldom is that the case. And so I think my opinion, which take it what it's worth, that this whole section on livestock ought to be done away with. I don't think we are doing justice to the livestock industry, and it's the wording in here has is poorly written as far as I'm concerned. Thank you.
Mr. Chairman, so I'll take a step.
Response from
Okay.
Representative Clausen.
Mr. Chairman, so I'll take a stab at this. So the livestock portion of this is old language that was cleaned up. So a lot of this is already in law. So what you see there, and remember, we rearranged a lot of these statutes in our first bill. But this is already in law. So the old language, read any peace officer, agent, or officer of the board, changes it to any person with authority. So most of this old language is there, and what we've done with the livestock portion of this is actually just clean it up. So the livestock portion of this is existing language. If you don't like this bill and you vote it down, this language is already in law. The way it's not stricken out, and it'll stay there. This is already law. So what will change is anything that's stricken out or underlined in its cleanup. So the portion that'll be added is the pet portion of the bill, if that helps.
Okay. Thank you, Representative Clausen. So we're going to have testimony from the livestock board, and they've been through this, and we've had other people look at it, and they may have some opinions as to why it's necessary. So I'd like for the committee to be open to that testimony when it does come. Any other questions on the bill, or do you want to go to testimony now? Looks like testimony. So I think our first person is going to be Steve True with the Livestock Board. And Steve, are you logged in now?
Mr. Chairman, I'm bringing him over. He should be there in a
Okay.
second.
Thank you.
You're welcome.
Mr. Chairman, good morning. Can you hear me?
Yes, we can. Good morning. Welcome to the committee.
Thank you, Mr. Chairman, and thank you, committee. Mr. Chairman, I don't know whether I should just ask for some questions or if I should approach a couple of things. One comment I think, or two comments I would make, I think up front is we also went to our legal officers and asked about the person of authority, and they said that was just that changing of that nomenclature there, because the previous bill has the definitions of law enforcement officers, who are become the persons of authority. In the case of our agency, that is our 2 investigators. So it requires any peace officer who has been through the post program, a certified peace officer, is a person of authority. So that's one thing. There's some new language in the livestock portion of the statute, that the forfeiture hearing, which it's something we can work with perfectly. It's something that Senate Judiciary felt was applicable, that adds that forfeiture hearing in between the time when an impounding agency may request disposition of the animal. So just as a big overview, with our only 2 investigators, the Livestock Board, we rarely would conduct an animal cruelty case now. Our role is education and consultation and advice to those agencies, sheriff's agencies around the state that are involved in the day-to-day enforcement of these statutes. So in context of that, some training material has been provided to different folks in your body, but something that I would mention is that the person of authority is probably not going to seize them, because we train that you don't ever impound an animal without the advice of a practicing veterinarian. And we typically prefer that to be a local veterinarian, with our state veterinarians to come in and, if requested, to come in and confirm that condition score up front. So that in reference to Representative Winters' question about the person of authority making that judgment, the training that's involved with that is never made without the advice of a veterinarian. So that's one part of the process. Included in reference to Representative Clausen's description of the current language, that forfeiture bond hearing is added in. Previously, there was in the protection of livestock animal statutes, I'll do it in an example, maybe that will help. We'll say that any county happened to impound 100 head of cows that were starving, or being believed to be starving. So cost of care on those 100 head of animals is extremely expensive. And so what would happen under current law is that impounding agency has to do an economic analysis of the case and that cost of care. And at some point, the value of those animals is exceeded by that cost of care. So the impounding agency may have asked to dispose of those animals. Now, in old statute, that required to be under the case where the defendant had not posted the bond. So we'll take the owner of the 100 cows says, no, I can't afford, or I'm not going to post that bond for cost of care. So now that price falls totally on the agency. Maybe day 10, day 15 in there, the agency says, we can't recoup the cost of care while this case continues. We need to dispose of these animals. That references, again, the Livestock Board and the estray statutes, where we are merely the mechanism by that piece of the estray statutes, where the Livestock Board becomes the mechanism for the agency, whoever that may be, to dispose of those animals through that sale. So that has been in current statute. But now there's been added that advent of that forfeiture hearing is required in between. I understand completely where that comes from. That maybe cleans up the process a little bit. And it still allows through the time frame in statute for that impounding agency to make that economic decision. In the case of a defendant who did not post the bond, they can say, okay, we're going to need to pull a trigger here, or we're going to be way deep in our budget and cost of care of this livestock. So then they will request a hearing, can go to the forfeiture hearing. The judge can say yes or no. Yes, you may dispose of the animals. No, you may not. So that's probably a bigger piece into the livestock portion of the statute than anything else. The way we look at it as an agency with just the two officers who, as you recommended or mentioned, their main role now is to train these other agencies, or as Representative Winter mentioned. Is that something we can train? Is that trackable in the process? And the answer to that would be yes. So that's
Mr. True, can you turn your volume up? We're trying to get you turned up. I can hear you pretty well, but you're not quite loud enough.
Does that change it, Mr. Chairman?
I didn't notice a difference.
I think it's in my camera, and I'm not probably techie enough to change the
Okay.
volume in the camera. So I'll
Go
just
ahead. I think we can hear you okay. I'm not sure as you're quite as loud as we'd like, but go ahead.
So having said all of that, if that helps in a little bit of the explanation, that's the livestock board's role, and that's where we see that statute. Can we teach that? Yes, we can. I think the forfeiture hearing, I fully understand where that came from Senate Judiciary, and so that's something we can work with as well. So I think I would stop there, Mr. Chairman, and stand for any questions from your committee.
Committee questions? So I've got a scenario that, and this is something I've heard about. A person has his animals impounded, and they were livestock. And before, I don't know if the bond is something that's new, I believe, in this legislation, but the animals, as they accumulated costs in care, were disposed of. And in court, the man showed that won the case at any rate, and the animals then are gone. Have you heard of any of this going on? And what did we do under old statute? Because I think that's what prompted this part of the livestock end of it, is people could lose their livestock, win their case that the livestock weren't abused, and then the animals are gone, long gone by the time they hear all of this.
Mr. Chairman, I am aware of that example. Without talking about a particular case, I would say that under current law, the cost of care bond, so here's how we teach that. If an agency makes that impound step, if they have a veterinarian's advice to make that impound step, and they take the animals and impound them, then it's their responsibility to have a cost of care bond hearing, ask for that within 10 days of that impoundment. That's when the judge will then set a bond for impoundment based on the average case per day or cost per day of the care of the animals board and all that. And that will be then the price. And then the defendant would be asked, will you post this bond? And if the defendant says no, then the agency is responsible for that cost of care price. So that's where now, previously, then that agency would have got to that line of that economic analysis and said, we got a fish or cut bait here because we can't afford to feed this amount of animals for another X amount of days at this rate. So we're going to use the old statute and use trigger the estray statutes, and we would dispose of those animals at public auction. So the new statute now would insert that forfeiture hearing prior to that disposal. So that's useful. It probably protects the defendant's position in the ownership of that livestock that's his livelihood in a better case. But there's also the case of the agency would certainly prefer that the defendant post the cost of care bond. As Representative Clausen said, that's the normal cost. They would be paying those normal costs of care if the animals weren't impounded anyway. And then the whole process can be a little slower and a little more deliberate. But if the defendant does not post that bond, that agency still has to make a decision. But now they would go to the court and request that forfeiture hearing probably a week or so ahead of when that line comes, when they start getting upside down in the cost of care. And then the judge makes that determination rather than the agency just saying, we need to get out of this. So that's probably a case. I don't know these cases. There may be prosecutors in the room are waiting to testify. I think these cases are pretty hard to prosecute. So there's that part of the game. I would just say quickly that some of the things we teach with our law enforcement is pictures every day if you have the animals, because it doesn't take very long to clean up a hungry looking cow or a hungry looking horse if they're getting proper feed. So your evidence changes daily. It's not like you took the car and put it in the impound lot and it looks the same on day 20. These animals will look a whole lot better, and sometimes that makes the cases hard to prosecute as well. So that was pretty long-winded answer. I hope I answered your question there. One thing I would note that I have heard, I have not heard this particularly from the defendant, but I have heard reference to the fact that defendants have been told when animals are disposed that they can't buy them back. That's not true. That's not true at all. If those animals go to public sale, they're as free as anybody else. It's just simply to their if that agency needed to pull the trigger and those animals go to public sale, if that defendant has not posted the bond, he can buy them back. There's nothing in statute shorter or nothing in law short of a court order from the judge saying you can't, that would preclude that person from buying those livestock back. Mr. Chairman.
Representative Winter.
Thank you, Mr. Chairman. Director True, could you explain a little bit more in detail as to what the training is involved for these police officers that are in the different counties as far as assessing these crimes or these situations anyway? Thank you.
Mr. Chairman, Representative Winter, I'll be glad to. That we train on all livestock law. We have a 4-hour accredited class through the Law Enforcement Academy, training on all livestock law. So, but the bulk of the training that's asked for, the questions we get is on animal cruelty cases. So we would start to give you an example of part of the class. Our investigators would teach, okay, you get the call, you go take a look at the animals and see, and if they look bad enough to you, you would ask a veterinarian to come and confirm the condition on those animals. We also train to be very careful about the context of the calls. Many times the calls are people that simply don't know. They don't see feed or water, not knowing that it's over the hill, or they don't recognize a fit horse that's living next door to one of my retired fat horses, and they think the fit horse might be fairly poor. So that is to take the context of the call, treat it just like any other investigation, ask the questions they would ask. But before making any impound decisions, we coach that you make several contacts. Because of the way we teach it is there's actually two kinds of cruelty. There's passive cruelty, which can be neglect or lack of information or lack of knowledge about the proper care of an animal. And there can be aggressive cruelty, which is somebody actually doing damage to an animal right at that time. Those are treated different. Officer discretion, same as any stop they make. They weigh those decisions in every contact they make. But if they think it's a passive cruelty, there's many questions to ask. We'll use an example. There's one poor horse in a pen of 6. So is that horse old? Have you had him a long time? Have you had his teeth floated? Is he sick? All of those kind of questions to kind of get to where what might be the cause. Maybe this is an older horse in with some younger horses, and that's the difference in look. So we teach just to do a basic investigation all the way through to try to get the entire context. Many times, and there are there's many sheriffs in the state that are really good at having that heart to heart with that owner, that, these don't look good enough, and I'm going to be back every week for a month. And if they're not looking better in a month, there's other steps we can take. And that's the way we coach to do this. There are citations available, and there are new citations and new penalties available in the companion bill that's already passed. There's many ways to work this prior to an impoundment. I would tell you that in the 6 years I've been here now, the livestock board has only actively been involved in one impoundment that had 38 prior contacts. We have not been actively involved in the starting or the beginning of any other impounds in my 6 years. Impounds of livestock are pretty rare. So I think the sheriffs are pretty careful about trying to do that the right way. And I think this forfeiture hearing in there is a pretty good interruption in the process of making it, of where it looks like the defendant might be getting steamrolled. They aren't, but it could look that way in certain cases. And I think this forfeiture hearing clause cleans that up. Mr. Chairman.
Committee, any questions? Yeah, go ahead. Representative Clausen.
Director True, just for clarity, so we have everybody on the same page, you understand where we're at. So in this portion of law or livestock, there are three things that I think we need to take care of with this bill. So private property rights of the owner, which I think we have a pretty good job of. These animals are also evidence, so we have a way, if they were abused, to preserve the evidence. And then they're living creatures that require care, and we have a methodology to make sure that that these living creatures that require care are taken care of. Am I right in those assumptions with this bill?
Mr. Chairman, first and foremost, as an enforcement regulatory executive branch agency, I'm not going to opine on your legislation, but those, as I said earlier, I think the changes in this bill are all things that we can teach and we can help enforce, and that offer no obstacle to implementation of the law as written here.
Okay, one more question from all
Mr. Chairman, Director True, the other portion of my question. So in statute currently, you have the ability to impound livestock, and with this bill, it adds an extra protection for those livestock owners where they have a forfeiture hearing. Am I understanding the process right? Going from current process to if this bill was implemented?
Mr. Chairman, Representative Clausen, that's a clear reading of that. If any of you have your green book in 1129-114, Section B, Romanet, Section D, it says if a bond is not posted, which was the references to the cost of care circuit bond hearing or bond hearing in circuit court, the bond is not posted, the board shall dispose of the animal as defined in the estray statutes 1124-101, which is sell, slaughter, or destroy, and you've added adopt to that. So that was the process prior to. When it says the board shall, that just means we're the mechanism. Our brand inspectors will then identify the animals and allow them to go to public auction. But yes, that forfeiture hearing now is in the middle of that process. Prior to that disposal, that will come with a court order now to the ruling from the forfeiture hearing. So yes, I think I think the way you explained that is right. That adds a step that protects the defendant's rights there.
Okay. Yeah, go ahead, Representative Wharf.
Yes, Mr. Chairman, I have a question. I have a couple questions specific to the livestock section. The one that I'd like addressed, I'm not sure. I noticed on page 8, lines 7 and 8, we have stricken the nutritional care, veterinary care, and diagnostic testing. Yet when you go back and look on page 2, that same language is included in the care for what I'm assuming is domestic pets. We still list out, in fact, we added the cost for transportation, board, nutritional care, veterinary care, and diagnostic testing. And I'm wondering why that language is kept in one section and it's omitted in the livestock section. And I'm not sure if that's appropriate to Director True or who that question should be asked, but that's one question. And then the way I understand on page 9, a person could actually post the bond and actually still find out that after they posted the bond that the animal's been disposed of anyway. And so I'm thinking, if I posted the bond on my animal and the state disposed of that animal, how do you resolve that? Because I'm just going to ask that question. If I'm understanding that right, that's what I understand. And that's on page 9 in that section. It's a new language starting at line 9, going to line 20, just so you know where I'm looking. So those are 2 questions specific to the livestock section.
Okay. Mr. True, do you want to answer that, or Representative Clausen can do that as well?
Mr. Chairman, as to the reading of your bill, I would prefer that Representative Clausen take a shot at that. I think I know what he's going to say, but I would prefer that he answer that one.
Yeah, go ahead.
So I'll take a whack at the first portion. So on page 8, lines 7 through 8, where it's strucken, if you look, we moved that language up to the top of the page line 1 through 3. So the part that struck, nutritional care, veterinary care, and diagnostic tests shall not read impounded but are not limited to costs for the transportation board, nutritional care, veterinary care, and diagnostic testing. So that's a reword. Are we clear with that one?
Where was it moved to?
Just
Representative Clausen.
Mr. Chairman, page 8, it would have started line 6 through 8.
Yep.
Now it's moved up from line 1 through 3.
Okay. All right. So it was shifted to another spot. So it's in
Shifted to
both
another spot.
the pet statute as well as the livestock statute.
Okay.
And I can take a stab at the other part if you want me to.
Well,
Or you can.
I can take a whack at it if you don't.
Go ahead.
So your other question would be in page 9, right? Through in the section 9 through 20. All right. Now I'm going to take a whack at this one. And I may have to have our good attorney that deals with this take another whack at it if I get it wrong. And he can tell me if I've got it wrong. So posting of the bond shall not prevent the person with authority to enforce this section, disposing or impounding livestock before the expiration period of the bond if the court orders the forfeiture. So the person has their day in court before it's forfeited. So you can put the bond up. The person, and I'm looking to make sure I'm right at getting this right. So you put the bond up. You go to court. The judge decides, yes, you have a violation or there's probable cause for a violation that you were doing some sort of animal cruelty. Or he says no. If he says no, you either get your bond back or the animal back and you go on with your life. If he says yes, then they forfeit you can automatically forfeit your livestock, or you can put up the bond that's cost of care and they take the care out of it. I want to make sure, am I getting straight off? I'm close. Because it gets, is that a good explanation, or I'll keep going, or we can get somebody that really
Well,
knows?
Mr. Chairman, if I may, I just, that does help, because the way I was reading that, I thought I could pay my bond show up to court and find out that the animal's been disposed of, and I'd be going, well, wait a minute, you know? So I did misunderstand that. I appreciate the clarity on that. So thank you, Mr.
Go
Chairman.
ahead.
So, Mr. Chairman, in the old statute, the way the law currently is, that could happen. What we do is put this extra step of a hearing, and that is the process of the hearing. And I'm sure I messed it up a little bit, but if you're clear.
Yeah.
Well, and when we
This
talk
is-
later, I'll explain why I'm asking this question. Thank
Yeah,
you.
I believe this part acts as a safety guard maybe for the statute so that the animal isn't forfeited before he gets his day in court. Representative Winter.
Yes, thank you, Mr. Chairman. We've been talking about the veterinary responsibilities, and in this first paragraph on page 7, line 9 through 12, it talks about, no, wait a minute. Line 13 through 15, it talks about, in the old language, it was the livestock animal was determined to be treated cruelly by a licensed veterinarian, but that's been stricken. So why is that? And I think it ought to be in there. I do not trust the ability of these people that are in law enforcement anymore to know what, if an animal is being mistreated or not, especially on horses and mules. There's some thin ones. Maybe they've been worked hard but if they got feed and so forth, what's the problem? But I just don't think that these people, or I think they ought to be trained to where they can understand what really goes on out there and not subject livestock owners to this type of treatment.
Representative Clausen.
Mr. Chairman, so I had that same thought, and I was gonna bring an amendment to put that part back in. But if you want to bring that amendment, I'd sure let you.
I'm not sure, but I'm thinking it may have just been moved.
I haven't seen it anywhere else.
Okay. We'll ask questions on that with someone who probably has looked at that portion of it before we get there. So are there people here that wanted to testify on the pet portion of this bill that's brand new statute? Mr. Illaway, why don't you come up and talk with us a little bit and maybe tell us why you believe this will correct some problems that we've had in the state of Wyoming.
Pete Illaway. Served in the legislature for 14 years. So I do understand some of the questions and how we look at bills. This particular piece of legislation is Senate File 25. Senate File 24 talked about bond and disposition. That was not really heard. Senate File 26 talked about animal abuse statutes. You did hear that. You'll notice page 6 and 7 of Senate File 25, that a portion of Senate File 26, which became Enrolled Act number 12. It was, you went through it earlier in this session in January. I know that, at least I hope that, and I want to say thanks to Steve True. I think Steve did a great job on talking about animal impoundment, and animals are either dogs and cats or they're livestock. And I do understand where Steve's coming from, and I think he did a great job, and I appreciate it. Let me just say a couple words, and I think the animal shelter director for Cheyenne is probably in the waiting room. But let me just tell you why some of these things came up and why the bond and disposition was necessary. And we've been working on it for a number of years, and fortunately, the Ag Committee was presented this in the interim. And I think they did a wonderful job in trying to put things together. It's been tough. But let me just talk about 4 brief cases why it's become necessary in the Cheyenne Animal Shelter. And I'll not only talk about the animal shelter, but I believe it happens throughout the state with other animal shelters. The first case was 10 dogs impounded on June 26, 2019. They were released from the court on March 30th, 2020. They were cared for 256 days. That was 2,560 days of boarding at $25 a day. It cost $64,000. There was an impound fee and then the boarding cost. And the Cheyenne Animal Shelter bore the entire cost. There was a public nuisance case with Rottweilers. There were 2 dogs. Total days of care was 170 days. They were boarded for 170 days. The 2 dogs cost $8,500. Totally paid for by the Cheyenne Animal Shelter. There was a bite quarantine court hold, a large animal pit bull terrier. He was impounded from October 7th, released in July 2020, 276 days, $6,950, all paid by the Cheyenne Animal Shelter. It goes on. The total cost in 2020 was $81,775 unrecouped loss. It was equal to 34% of the county animal control contract from 2019 to 2020, which amounted to $236,000. The Cheyenne Animal Shelter is assisted in by the county. They provide some funds. The city of Cheyenne provides funds, but it is really a donations, and that's how the Cheyenne Animal Shelter survives. I can tell you that when you have a case that costs $81,000 and you have no way of having those costs recouped, it is very tough on the animal shelter and their budget. So I think the committee did a great job on looking at and melding together the animal abuse statutes and the animal impoundment proceedings. I do understand Representative Winter's questions. And quite frankly, from looking at the bill, that would be Steve True's thoughts about, he talks about the veterinarians. I don't think there's any problem with Representative Clausen putting that section back in. I don't think that's going to hurt anything. So I think the bill has been worked on in the interim. It's been worked on by the Ag Committee in the Senate and the Judiciary Committee in the Senate, and now the House Ag Committee. So we would appreciate you moving the bill through. And if you have any other questions, well, I stand for questions.
So I've got a question so I'm clear on it. On the pet portion of this, you'd never have this 256 days, none of that. It would be within 7 days of the petition. There'd have to be a hearing.
Mr. Chairman, and you're correct. Within 7 days, there'd be a hearing, probable cause, and bond would be started. And there is no way of doing that now. So,
Okay.
that is why we came to the Ag Committee, what, a year and a half ago, and asked for this to be looked at because of the expense that we have run through.
Okay. And I think it's longer than a year and a half ago. I've seen it worked all the while I've been in legislature, and I'd like for us to be able to correct some things. Representative Winter.
Yes, thank you, Mr. Chairman. The fellow giving the testimony today, I forgot your name, I'm sorry. Have there been any criminal penalties issued for these violations with pets other than just a fine? Or even, is there even a fine? They have to post a bond, but has there been any fines or criminal penalties issued?
Mr. Chairman, Representative Winter, it's nice to see you. To answer your question, I hope the animal shelter director is going to visit with you for a few minutes. My understanding was, especially with the 10 dogs, that they were impounded, they were boarded, and I believe eventually they were adopted out. There was no fine. There's nothing that says there was a fine. And this is the problem with those statutes, that without probable cause and being able to go to the county attorney and so forth and getting bonds, the shelter is at the mercy of feeding the dogs, probably adopting them out and so forth. I think the one where I mentioned about the hound dogs, I think they were eventually, those dogs were eventually adopted out. But the shelter got no real money, and my understanding is I don't believe the gentleman had was any problem with it, that he was fined or anything like that.
Okay, thank you.
That would be up to the animal shelter director, I think, to ask her that question when she comes on.
Okay. Did you have any questions for Mr. Illaway, or do you?
Thank you, Mr. Chairman.
Okay.
Mr. Illaway, I guess I'm just kind of unclear about that total length of time. It just seems like it's an awful lot of time that you're holding those dogs. Is it mostly because of the courts, or help me out there, Pete, or Mr. Illaway?
Thank you, Mr. Chairman. Representative Blackburn can't answer the question wholly, except that I believe that that's one of the problems with the court cases, that it takes so long to go through and get it done. And this is why it's a 7-day hearing, 7 days, probable cause. I mean, it has taken that ability to move it into the court system and get the courts to take a look at some of these problems.
Thank you, Mr. Illaway.
At this time, committee, I'd like to bring on the animal shelter representative. I think Mr. Illaway was representing that industry as well, and I appreciate your testimony, and you'll be around for a little longer. Thank you. So,
Mr. Chairman, here she comes.
okay, thank you.
Okay, thank you, Mr. Chairman. I appreciate this very much. My name is Sue Castaneda. I'm the Chief Executive Officer of the Cheyenne Animal Shelter, and I just appreciate this time to share some of the situations that we've faced over the past few years. Thank you, Mr. Illaway, as well, for laying that out. In the case of the 10 hounds, the owner actually was found guilty of 1 count of animal cruelty. So there was a fine of $7,800, basically the restitution. He did pay $500 to his impound fee, But for the rest of that, we've had to send them to collections and we've gotten nothing. There is a fund through the Attorney General's office to reclaim money if there's an animal abuse case. But when I filed for that, I had to show eventually that I did try to go after the man for the money. So we got nothing. And those puppies, there were 2 adults and 7 puppies. And for all that time, the court cases just keep moving back, getting moved back, moved back, moved back. And then the person also gets, one way or the other, if they're found guilty, they also get 30 days to appeal. So that cost still falls to the animal shelter. So we've got those 7 puppies grew up basically in the shelter from 3 weeks old until they were 10 months old. And yes, they all got adopted. So that was a good thing. But they didn't know grass. They didn't know steps, car rides, anything. So it's very hard to adopt out a puppy that has to be fully trained. So fortunately, we're able to do that. Another case, we had 21 Springer Spaniels found in a woman's car that we held for 4 months that we finally had to just drop the charges on just to be able to move these dogs along. We made a plea deal, I guess, with the owner of the animals that she could have back 2 of the dogs as long as they were altered, and then we were able to adopt out the rest. So in all these cases, it falls to us to take care of the animals and then go after the person for the money. So this would just be very helpful to set this tone up ahead of time that there is a cost of care here. And as Representative Clausen discussed, many of these dogs, if they're held for too long, they do go kennel crazy. So even if they were adoptable animals at the beginning, when they're held here months on end, for all that we do for them, even enrichment and walks and such like that, it's just not good for any animal to be caged for months on end. And I would be open for questions. Thank you.
Committee questions? Yeah, Representative Heiner.
So thank you, Sue, for your testimony. As I read this bill now, it looks like a lot of your clients or the people that have their animals impounded don't have the wherewithal to be able to post a bond. They may not have that ability. So with the bill as it is, what would you do in that situation when they couldn't post a bond to be able to pay for the maintenance?
Well, that's where, thank you, Representative Heiner. That's where it falls to, if they can't post the bond, then the animal would be forfeited to the shelter for us to either adopt out, or if it's a dog that's been deemed aggressive or it's been too cruelly beaten, to be able to euthanize it. So euthanasia is, of course, not a path that we want to go down, but it is it's a more humane treatment than locking them up for months on end. So I hope that answers your question. Thank you.
So I'm clear on the process. The animal's not posted for bond. And even if they are, I'm thinking maybe you can do this. You put petition for forfeiture to the courts, and within 7 days they have to respond in this legislation. Is that with or without the bond? And is that the process you'd have to go through to be able to adopt the animals out?
Thank you, Chairman Eklund. The animal control officer who has the case will go to the court and ask for the bond. And if the person can post the bond, then they would be asking for the forfeiture. So it's always with the animal control officer overseeing that case.
Okay. Committee, any further questions? Representative Wharf.
Yeah, I'm really struggling with this, Mr. Chairman. I'm trying to support it. I understand there's a problem, but and I guess one of the questions I have before we have discussion about the bill, I don't see anywhere in here, and I don't know. It seems like to me we're taking possession of somebody's property, and we're spending money determined on what care cost that animal should receive. And then we're turning around and obligating the person that we just took it from to pay for all that. And what I'm just wondering if I don't see any way where, and maybe it's been tried, it's failed, but to me, it would seem more appropriate to leave the animal in the custody of the people that you think are treating them cruelly. Why incur the cost? Take them to court, let them have the animals in their possession. And if it's a problem, let the courts determine then. To me, we're not following due process. You're taking my property, you're assessing, basically, they're not fines and penalties, but you're basically spending my money to care for something. And I'm just gonna say this, I don't know how else to say it. Sometimes the way we care for something might not be the way somebody else thinks it should be cared for. My mom had a dog that she loved that dog to death, been with the family forever. It happened, she was working in our backyard that was unfenced. The dog walked out into the front yard. Somebody picked it up and turned it in. They determined that the dog was overweight, which it was. But he was obviously taken care of. They thought somebody had dumped him. It led to the disposal of my mom's pet. By the time we tracked down where it ended up, and you're talking the space of 2 days, they killed that, they disposed of that animal. And I just see, yeah, had she taken that dog to the vet probably would have told her he was overweight, she needed to do something. But that was a dog we knew was on his last leg. We would have rather have that dog die of natural causes than have somebody come take it from the family and dispose of it the way they did. And so I look at this, you know, we've heard some instances where I definitely think there is a problem, but a lot of this to me is the state interjecting itself into something that I'm very uncomfortable with this. I don't like the term person of authority or person with authority. That's just to me, I don't like that definition. But I guess the question I have is, have we looked at, is there a process where we could actually notify the person that they've been reported for animal cruelty, leave the animals in their possession, let the court run the process so that we're not incurring these costs. And then once the court's determined that an action is warranted, then take that action. Because I really do. I look at it, we're incurring a bunch of costs, we're spending other people's money, expecting them to pay it. I mean, I look at, if I got a $64,000 bill for my 10 dogs, I probably wouldn't pay it either. But if you're taking me to collections, that could take my house. You want me to forfeit my house because you took my dogs? And
So
I
can we,
just have a problem.
let's get the part answered that you asked.
Thank you, Mr. Chairman.
Ms. Castaneda. So the question in here is, does this new law that we're trying to pass protect the person? In this case, the abuse was too much care. And I'm a little surprised at how it went. How would this law change that process that his mother went through?
Thank you, Mr. Chairman. That does sound like a really unique case. I don't think that we've ever been upset with anybody for overfeeding necessarily. A recent case, though, that we had where we had 2 pit bulls that were left in a trailer house starving to death. They were, by the time the neighbors were able to call to notice and to figure this out, animal control seized the animals because they were hours within death. So they came to the shelter and we gave them medical care to revive them. I can't see in any situation like that where we would then turn around and give them back to an owner who was so cruel and abusive. So I'd find that very hard to do. And I think that what this bill does is allow that person to come and post that bond, gives them a chance to defend themselves. The Cheyenne Animal Shelter is actually a nonprofit organization that provides animal control contracts for the city and the county. We are the only one in the state that does it like that, but our what's happening is these things where the owners should be paying the cost of care is actually being absorbed in our budget and paid for by donors. And so if we can't figure this out with this kind of bill this year, then it's something that we're going to have to reverse back to the city and the county in the future. Hope that answers that. Thank you.
Okay, and I'm pretty sure they haven't got it figured out yet either, because I'm trying to remember, I think it was 6 years ago, we were working on some of the same issues. We had sheriffs testifying and whatnot. Run us through the process. So an animal is either running at large on the street or is being abused in some way. We're talking about pets now. We're not talking about livestock. Who picks up the animals? How does that all happen? How do you get them?
Thank you, Chairman Eklund. So when there is an abuse case, generally someone tips off animal control. They go and investigate, and they can't go in the house, although they do a lot of first responder assists with other cases. But once the animals are out of the house, then they bring them to the shelter. They file a case with either the city attorney or the district attorney's office. And so then the hearing is set up and they go before the judge to find out a court date for the animal owner and any costs to be incurred. Try to give an example of what we think it's going to cost. And this really has come up, as one of the other gentlemen had asked, because court cases just keep getting moved back and moved back and moved back for months on end. And so, we've just tried to figure out some ways to help the animals so they don't have to be with us for so long, and that our donors don't have to incur these costs. Thank you.
So that we're understanding the due process. They can't go into the house, look at the pets, or probably into the yard either. Then how would animal control pick up those pets?
Thank you, Mr. Chairman. They can go in with a police officer or the sheriff's officer. Otherwise, like the two dogs I said that were starving, they came out of the front door because they were so hungry. So at that point, we could get them, but we can go into yards. Animal control can. Thank you.
Okay. All right, that's what I needed to know. Do they have to have any kind of a warrant to do any of this that you know of?
Chairman, no, I don't believe so. Not going into the yard, no.
Okay. Any questions? Representative Heiner.
Thank you, Mr. Chairman. As I read in article or title 11, it says any peace officer, agent, or officer of the board may take possession of an animal as determined by a licensed veterinarian. So as I read the statute, they shouldn't be able to impound, but we're including that into this now. Aren't we? It's that same title is included in this.
We're trying.
So I guess my question to Ms. Castaneda is, could we impound without the advice or consultation of a veterinarian with this bill as it's being proposed?
Thank you, Mr. Chairman. Yes, you can, or the animal control can. The veterinarian doesn't really come into play in our world until the animal is brought into the shelter and examined by a veterinarian.
So as you read the bill, would that change? Would the veterinarian come in before the animal is taken in or picked up by animal control?
Mr. Chairman, no, probably not. The veterinarian doesn't normally go out on site.
Okay. We're trying to figure out where that part of how that part of the bill affects the process for animal impoundment.
Yeah. We can
So
discuss that.
if it's okay, we've piled up a few questions and concerns, and we have a house.
Mr. Chairman, I have one more question.
Go
for
ahead,
the good
Representative Ward.
director, if I could.
Yep.
I know that the idea of leaving an animal that's being treated poorly in that same environment, I don't like that any more than you do. But I've wondered, I know that you do have placement for rescue dogs and stuff like that. Has the center looked at trying to line up people that would be willing to take these dogs? Because I know you mentioned that they kind of get, once they've been in a kennel for an extended period of time, that's not good for the dogs neither. And I just wondered if there isn't a way that you could line up people that would be willing to take and care for those animals rather than leaving them in a shelter. I mean, I just don't know. I know that people will de-rescue animals. Have you looked at like a short-term adoption period where those animals, because maybe that helps with placement too, if it goes through the courts and they're found that those animals need to be taken from that individual, maybe that's easier to place them. I don't know. I just wondered if the shelters looked at asking people to voluntarily care for these animals rather than putting them in and having the shelter have to take care of them.
Thank you,
Yes,
Mr.
yes,
Chairman.
Anita.
It is not normally been something that we were doing because we are considered evidence, but I think especially after our experience with the hounds, it is something that we would be looking for rescue partners to, and with confidentiality about the fact where these animals are, but it can be done, definitely. Thank
Okay,
you.
thank you. So I'd like to call on Representative Crago. He is a freshman representative. He's a rancher attorney, and he helped us with the animal abuse statute that passed through the Senate and the House. And it was quite a lot of cleanup, and maybe he can answer some of the questions the committee would have, some of the concerns he would have in this as well. So can you answer some of the questions that we didn't address well? Go ahead when you're ready.
Thank you, Mr. Chairman. Barry Crago, House District 40. So here's what I would say without answering any question specifically. This bill actually is what I would call a sister bill to Senate File 26. They go together. And so a lot of the concerns that I believe Representative Winter and Representative Wharf and Representative Heiner have expressed, those concerns have already been dealt with in the previous bill. For example, we already have the right as law, speaking from my county attorney, put my county attorney hat on for a second. Under the new bill, we can already assess the costs of impoundment against an owner of whether it be livestock or a pet. That's already in the new law. And so what this bill actually does, it gives the owners of the animals some due process rights that they would not otherwise have. So as I read the bill, I actually think it is more protective of the owners of the animals than vice versa. It actually gives rights. It gives some due process rights. It gives some hearing rights. It allows you to, for example, to pay the bond. So if someone comes and takes your animal, you have a choice. You can either pay the bond, which is a minimum of 90 days care, or you can forfeit and say, I don't want the animal. I'm not going to pay the bond. And at that point, the caretaker of the animal can dispose of the animal through adoption or other means, sales or euthanasia, if that's what they need to do. If the animal happens to be an animal upon which you make your living, which would be in the livestock industry, if you can't afford the bond, you still get a hearing. And that was the provision that the Senate added in to protect livestock producers. I'm assuming that's why it was added in. It would also apply to somebody who was raising dogs or, cats or whatever for resale. It could apply to them, I suppose, as well. But it's typically, I would envision that being a protection for the livestock owner. Say they come and take 100 of your cows and you can't come up with 90 days feed cost for the cost of impoundment, you would still be entitled to a hearing before they could dispose of those animals, sell them or otherwise.
Okay. Questions? Yeah, Representative Heiner.
Thank you, Mr. Chairman, and thank you, Representative Crago, for being here to answer some of these questions. I appreciate your expertise and knowledge in this, but going back to Title 11, it talks about for livestock, you have to have the consultation of a licensed veterinarian. On page 2, line 1 through 3, it says any person with an authority to enforce this article and who has probable cause to believe there's been a violation. So who is a person that has, what authority or which people are we given authority to enforce in this article?
Thank you, Mr. Chairman. That's going to be
Cragel.
a law enforcement officer, whether it be a city police officer, or it could be a member, it could be a livestock board investigator, it could be a deputy sheriff. It's law enforcement. That term was defined. We defined that term in Senate File 26 to be a law enforcement officer.
Follow up?
Follow up, go ahead.
And do you train these law enforcement officers, the city policemen, to be able to recognize cruelty and the effects thereof?
To be honest, Mr. Chairman, Representative Heiner, I believe that's part of post. I can't answer that 100%, but I believe most law enforcement officers, when they go through post, are trained in that. And I think that's what the good director was referring to when he said most law enforcement officers are trained in that. I will tell you, from a law enforcement standpoint, there's a big difference between seizing or impounding livestock and dogs and cats. Because dogs and cats, it happens like this, the animal control officer picks the animal up on the street or something like that, like Representative Wharf alluded to earlier. That does happen. I mean, that's why we have dog catchers. Animals, I can tell you, livestock animals, rarely, and I don't know if I've ever been involved in one of these cases. One time, I think, and it involved a horse, and we didn't do anything without the vet. I will tell you that. We went to the vet. It was a livestock animal. Got the vet's opinion before the animal was impounded. And that's in, over a long time. They just aren't very common. They're much more common in the pet world than they are because of, I think there's just the circumstances don't really apply as much in the livestock industry.
So in the pet industry, go ahead, Representative Winter, before I ask anything. Go ahead.
Yes, thank you, Mr. Chairman. Representative, thanks for being here. And I don't have the same confidence in our law enforcement officers to deal with livestock. And you may have heard of the situation in my district where an old horse was shot by a deputy before they found out who it belonged to and a whole bunch of things. And it's deals like that I was glad to hear that the livestock board was going to do some training, but I have not seen it. And that's so important, especially in the livestock industry. There just aren't very many folks available anymore who understand livestock. And so we need to really address this situation before we pass this bill.
Okay. Representative Cragel.
Mr. Chairman, Representative Winter, I actually agree with Representative Glossen's proposal to stick the veterinary language back into the livestock side of the bill. As a prosecutor, working out of a county attorney's office part-time, part of my time's, I don't do much criminal work, but I'm involved a little bit. I would tell you that they're not going to have any problem with that language because they're going to get a vet involved anyways. I mean, that's just how we do it. So if the language goes back in on the livestock side of the bill, I think that would solve your concern and it helps the bill. On the pet side, I would say that's a little more difficult to do because you're, as was alluded to earlier by one of your witnesses, you are not going to have a vet available when you pick that dog up. That just practically does not work. And we pick up tons of dogs every day around the state. Not all of them get impounded. They might go to the shelter until we can figure out who the owner is. And a lot of times it's just, it just happens so quickly that that's not really an option. Livestock's different. And I think I would agree with you.
Okay. But Representative Wharf.
Yes, thank you, Mr. Chairman. I have a question and welcome Representative Cragel. I've been in his committee the few days I've not been here, so it's fun to have him in my committee now. I did have a question. Can you tell me what other law is on the books where the state or the court can take an action that obligates an individual to incur continued cost while something is working through the court system.
Representative Craigo.
Mr. Chairman, Representative Orff, I guess sitting here, just thinking off the top of my head, I'm not sure of any. I'm sure I can dig that out, and I would assume there are others. I just sitting here, I'm drawing a blank, and I apologize. What I would say is, if without this bill, we still, law enforcement, the courts, the prosecutors, skits can still require the defendant to pay the impound costs. That's already in law. It's in the law we passed. It was already in the livestock side of it anyways. Really what this bill does is take a lot of the stuff from the livestock side and slide it over to the pet side. I mean, that's really what it did. They reworked some of the words, but a lot of the stuff we're talking about today has been law on the livestock side for quite some time. Now they're just giving our local officials the ability to deal with, it's twofold. Gives our local officials the ability to deal with pets, because they have the ability to figure out what to do with livestock. Now we can do it with pets. But on the other hand, it creates this extra barrier of process for the owner that they really didn't have before. They weren't entitled to a hearing prior to this bill. The animal could be disposed of without their permission. And at least with this bill, if you post the bond, or if the animal relates to your livelihood, you're entitled to a hearing before they can give the animal away, adopt it out, or dispose of it.
Follow up, Mr.
Go
Chairman.
ahead, follow up.
And I appreciate you trying to answer the question of where else this exists, because, you know, as I said in your committee, I'm not familiar with the legal system as much as you are, but that's probably the biggest problem I have. And you say that it's already on the books, and that this is allowing the victim an opportunity to have kind of their day in court. You know, I still struggle with the fact that we're actually imposing on people. We're interjecting the courts into, to me, with pets. You're talking about family. I mean, it was devastating to my mom when that happened. And it took us longer to find out what happened to her dog than it took them to dispose of it. That's how quick it happened. And this is a dog that was my mom's companion, wake, night. I mean, they were together constantly. Like I said, he just walked off. So I can appreciate this, but I still, you say they either pay the bond or they forfeit. And I still struggle with the idea that as courts get delayed, it may have nothing to do with me, but the court's backed up. They have to keep kicking my case out. Every time they kick my case out, that's adding more costs to me. And I don't know if there should be something in here that addresses that if it's outside my control, such as, you know, the court has to keep kicking my trial date back.
Okay, I think
maybe there
he
could
can
be some
answer
relief.
that.
Yeah,
If you've
could there
got
be
a-
some relief added to the bill for a situation like that?
All right, and I think that the bill it addresses what happens. Could you kind of walk us through why what happened in his case wouldn't happen with this statute in place?
Thank you, Mr. Chairman. Representative Worf. So what I would say is, the way the process is set up in here's what happens. Let's take your case and use it as the example. So the dog gets picked up. The problem in your case is you didn't know, and they didn't know who the dog even belonged to. I don't know if any law we have necessarily fixes that problem. This isn't going to fix what you're talking about, but neither is any other law we have, right? So that's to be honest with you, I believe that's a different subject than what we're really talking about today. And so, but let's take that and let's assume they figured out that it was your mother's dog. They would notify her. She'd get a criminal citation, right? She'd get a citation for cruelty to animal under the new statute SF 26. She would then be required, and they would have initial hearing. court would set a bond for whatever the cost of that care would be for that animal for the next 90 days. She could post that bond. But what would more likely happen in your mother's case is she would walk into the judge and say, Judge, my dog is overweight. It's not abused. Let's look at him. And the judge would say, you're right, case dismissed, right? I mean, that's realistically what would happen in your mother's case. There wouldn't be a trial, there wouldn't be an impound. The dog would be back with your mom within a couple days. However, whatever the statutory requirement is for the initial hearing. That case is easy to deal with. But let's assume that the animal actually is being abused, or it's borderline, right? There's an argument. Usually there is no argument. I mean, I think when you get into pets, typically there is not an argument. The animals, it's usually pretty clear cut. And that's what this statute is really trying to address. But I'll get back to that in a second. Let's assume there actually is a debate. Your mother could have she can pay the bond, the 90-day bond. Or if she decides she can't afford the 90-day bond and doesn't want the dog, doesn't want to pay for the dog's care for the next 90 days, she just says, I forfeit. Those are her two options. If she pays for the bond, then the criminal proceeding goes on, just as it would. Typically, your misdemeanor, this is going to be a misdemeanor case at this point. And so it would go through circuit court at its usual pace, however long that takes, 6 months. It could be quicker, it could be longer. Just depends on the court's jurisdiction. But that dog would be in the care of most likely the kennel, pound, shelter, one of those three things during that time period. At any time during the way the bill is set up, at any time, the people taking care of the dog, whether it be the pound, the shelter, if it was livestock, it could be the sale barn or somewhere else. They could petition. They could tell law enforcement, hey, we need to do something with this animal, or law enforcement can make that decision. And then the prosecutor has to have a hearing before they can sell that animal or get rid of it, euthanize it. And that's what happens. If you decide you don't want to pay the bond, or if it's a animal that you make your living off of and you can't, which is possible. I mean, if they come and take 100 of your cows and want you to pay for 90 days of feed, that might be hard to do. And so that's why there's this safety valve within the statute that says you're entitled to a hearing no matter what. And at the hearing, the prosecutor then has to show probable cause that you've abused the animal, which is essentially a trial. I mean, it's not quite a trial, but it's one notch below that. And they're going to have to show that and prove to the judge that you've committed animal abuse. And so it's a hearing. I mean, we have probable cause hearings all the time. Anytime you go to a felony case, you have to have a probable cause hearing.
Representative
So,
Wharf.
Mr. Chairman, one more follow-up, and I'll try to be quick. I know you're trying to hurry us along.
We're going to be continuing this. We can't do our amendments nor have proper discussion. But ask questions while we've got an attorney here.
Yes, one of the questions I have is, if there was an incident similar to my mom, where somebody inadvertently picked up an animal, and rather than he was disposed so quickly, maybe it took us 3 days to find out where he was. Does this still obligate the dog to be impounded for 90 days? Or if you were to show up and say, look, honest mistake, he got away from me. Can I get my dog back without having to go through 90 days of impoundment and paying all that additional cost? That's a question. Thank you.
Mr. Chairman, Representative Wharf, it does not require you to go through this proceeding. I would assume, and this is just speaking from my experience, that there would be no criminal action. Your mom would go to wherever the dog was being kept and say, hey, that's my dog. Why'd you pick it up? And they would say whatever they said, and that'd be the end of it. That's why I said I don't really think that neither this bill nor the previous bill we already passed through both houses would apply to your mom's situation. I think that's just an unfortunate set of circumstances that shouldn't have happened, but did.
Thank you, Mr. Chairman.
Okay. Representative Winter.
Thank you, Mr. Chairman. Representative, is there an investigation conducted prior to any impoundment of animals, whether they're livestock or pets, prior to them impounding them?
Mr. Chairman,
Quaker, go
Representative
ahead.
Winter, yes. Typically, yes. Not always on pets, I will say. Sometimes that just, like I said, if the dog catcher catches a dog running around town, that would be a different situation, but livestock are a little more stationary typically. And yes, in my experience, there's always an investigation conducted before impoundment happens. The only caveat I would say to that, and this this hasn't never happened that I know of in our jurisdiction, but if for instance, let's say you find an emaciated animal out on a road or something and it has to be picked up. Let's say it's wandering down the right of way on the state highway, we'd pick it up. I mean, you'd figure out a way to get that animal off the highway for safety purposes, but that would then start the investigation of what would happen. You know, that would begin the investigation into whose animal it was and why it was where it was, why it was there, why it was not properly cared for. But typically, I'm going to say 99% of the time, especially on livestock animals, there will be an investigation first.
Okay, I know a little bit about how it works if there's livestock on the road. I live on 85 and the highway patrol has a list of people who live near places and it isn't long before you've got some ranchers somewhere with four-wheelers, whether they're, or horses, whether they're cattle or not, getting them off the road so that no harm comes to the public or the animals. So we're going to have to continue it. And it'll require more discussion than we've got than we can do. So I'm going to adjourn the meeting if there's no further questions. Oh, Ms. Reallaway has a couple more comments. Come on up, Pete.
Mr. Chairman, committee, and to my friend Representative Worf, our dogs get loose in Cheyenne. They did before we moved out north. They get picked up. They're generally, most dogs anymore are being chipped. They find out what the chip says. They call you, your dog's here. We go down, pay a fine, pick the dog up, come home. And the chipping has been going on for years. It's worked very well here in Cheyenne. And I know because we have paid the fine for that. So, I mean, don't think bad things about shelters. I will guarantee you that they are saving lots of dogs and they work very, very hard. I know the Cheyenne Animal Shelter works extremely hard to protect animals, to make sure that they're returned to their rightful owners. There are times when there are hoarders or there's animal cruelty, and this is about the only way to take care of it. Okay. And as far as that a particular amendment, Representative Clausen, I would certainly go ahead and put that back in. You know, they went through and worked.
Won't be until Tuesday.
No,
we gavel in a few minutes. So
okay, but thank you very much.
Yes. Yeah.
Appreciate it.
And we might see you Tuesday again. We'll see. Okay. All right. So Carol, we're going to continue the discussion on Tuesday. We'll start with this bill. We may have a little more testimony, but I want everything sorted out by the committee before we really chew into it any further.
Chairman Clausen, if we don't have any other bills to the floor, would you suggest 8 o'clock again instead of the 7 o'clock?
I'm not sure.
Okay.
I thought I thought 2 hours would get us done this time. So probably we'll normally think it's going to be 8 o'clock, but if we add another bill, it'll certainly be 7.
Okay, I'll check
Okay.
back with you then. Thank